All right. Welcome to the September 21st, 2009 special called work session. A work session is a more informal setting to update the council on business items. No votes will be taken. Tonight, there's one item on the agenda that was postponed from the September 14th work session. Public comment is allowed that is germane to an agenda item. If you wish to speak, you are required to fill out a public comment card and turn it into the city clerk's staff. Public comment will be allowed for a total of 10 minutes per agenda item and no more than 2 minutes per person. Public comment will be heard at the beginning of each item. Once the item is called, no more public cards will be accepted. Will the city clerk please call the first item?
Yes, sir, and for the record, we don't have any public comment on this item. Discussion on the criteria that must be followed when considering variances. Mr. City Attorney.
Mr. Mayor and members of the council, thank you. Val, are you okay? Okay.
Where's Sadiq?
He's on vacation.
First of all, thank you for allowing me to do this. Let me explain the genesis of why we're even doing this evening. The zoning ordinance was modified this year, and the city council now has the ability to consider concurrent variances as part of zoning relief. The Board of Zoning Appeals and this council, as you know, went through a fairly arduous labor of love to come up with some new variance criteria. And we have spent quite a bit of time with the BZA going through with them how to apply these criteria and the legal standards, et cetera, but have spent no time doing that with the council. And so the thought was perhaps it would be appropriate to do that for you as well. You can ask questions. I have prepared a couple of things for you. At the last work session, I had handed out a little memo called Georgia Case Law on Variances. Just contains some case blurbs about some of the controlling law with respect to variances. I also have in front of you just a section of 22.3.1, which is the variance criteria. And then I also have a little sheet called Items for Consideration regarding variances that I reprinted this evening. And you can maybe take some notes on that if you want to. And we'll go through those things. And those are basically just anecdotal tips that I have that since I've been doing this for 15 years, I can share with you some of the things that I have seen that work and don't work in the realm of variances. So let's start, if we can, by the zoning code. We'll go through that very quickly. Then I'll hit some of the case law, just about some general broad concepts. And y'all, of course, as you know, just ask questions at any time. You can interrupt me. You don't have to. There's no protocol to this unless the mayor wants there to be. Yeah, let me see. Here's another of the zoning code, and then with respect to there we go. Perfect. All right. First of all, with respect to the zoning code itself, section 22.3.1, we spent a lot of time on this with the Board of Zoning Appeals, and let me just go through them. First of all, you can understand that this is fairly typical variance criteria. There is nothing way outside the four corners of what I'm used to seeing in other jurisdictions, with one interesting caveat, and we'll talk about this. We'll talk about that. 22.3.1 says, and let me just begin with the preamble as well, a variance must be based upon credible evidence. And just to stop right there to make the council aware, that does mean that there is a burden upon the variance applicant. The applicant has a responsibility to provide to you facts, evidence. Now, I'm not suggesting to you this is an evidentiary hearing where people need to be sworn in, but I am suggesting to you there needs to be a showing. And the credibility and the merits of the proof are up to you. Each of you sits in a quasi-judicial function as you hear a variance, which is different than your typical zoning hat. When you are doing zoning only, you are acting as a legislative body. When you are acting as a reviewer of variances, you are acting as a quasi-judicial capacity or a quasi-judge. And what that means is that you hear the facts and then you apply them to the law. And the law is what you adopted earlier this year. That's the law. So you do have to hear evidence submitted at a public hearing before the BZA, but in this case, of course, it's in front of you. And your code is very clear that when you hear one of these concurrent variances, you apply the same standards that the BZA does when it hears a primary variance. You apply the same criteria. What are those criteria? To vary from the rules that you have set in place. Number one is that if you grant the variance, would that relief not offend the spirit or intent of the ordinance? And we're going to go back through them in just a moment, but let me just hit them. Semicolon, this is important. It then says and of course we all know what that means. It's different than or. It means that that is simply one of 4 criteria that must be satisfied. It's a fairly onerous standard. So that's number 1. If you grant this variance, will we offend the spirit and intent of the code? Number 2, and this is, I guess, the meat and potatoes, if you will, of the variance statute. You have found in your own discretion that there are such extraordinary and exceptional situations or conditions pertaining to this particular piece of property that the literal or strict application of the ordinance would create an unnecessary hardship due to the size, shape, or topography. Now that's one. I want you to think about this because this does something a little clever in this code. Or other extraordinary and exceptional situations or conditions not caused by the variance applicant. So within B, there are basically 2 bases for relief. The first one is based upon the size and shape and topography of the property. And in a lot of variances in other jurisdictions, that's it. That's the only criteria upon which you can get a variance. Thus, if you have an unusually configured piece of property and, say, a riparian buffer that goes next to it, or maybe it's got double frontages on roads such that there are a lot of setbacks, you may conclude, because of the significant burden that puts upon the property owner, that a variance to, for instance, the strict interpretation of the setback or the strict interpretation of the buffer or some other requirement needs to be varied or waived or mitigated or lessened to avoid causing a burden, an undue burden on that property owner. That's one of your variance criteria. But check out the or in the 4th line down, or other exceptional and extraordinary conditions not caused by the variance applicant. Now, you'll notice that the not caused by the variance applicant doesn't apply to the size, shape, and topography language. It's not in there. It's only in that second subpart, which is a little curious because under standard rules of contract construction or statutory instruction, if a thing is included in one area and not included in another area, there is a presumption that arises that that was purposeful, which means that since it wasn't added in the context of size, shape, and topography, that if the applicant caused the problem with the size, shape, and topography, that does not work as an automatic bar to giving the variance. But in the second one, or other exceptional, extraordinary situations or condition not caused by the variance applicant, if your applicant created the condition that necessitates the need for a variance and they caused it, they created the situation, that works as a bar to your review of their variance application. Does that make sense what I'm trying to say to you as far as the distinction between the two?
Can you give us an example of something that maybe you've seen where, just a general example that pops to mind, something that someone would have created themselves?
Well, a lot of the times, what I'm used to in variances is that individuals are coming in and asking for forgiveness rather than permission in the variance context. Now, let me try to answer your question in a 2-step process because, first of all, let's think about a variance that you would need that is not related to size, shape, or topography of property. Let's think about that for a moment. I have seen, when I used to attend the BZA meetings, and certainly I've seen this in other jurisdictions as well, the inevitable basketball court or the cabana or the pool. And you have to ask yourself now, is that a variance when they need, typically what they need is they want that variance because the pool goes too far into the setback or the pool goes too near the buffer. And you have to ask yourself, is that a condition on the property due to the size, shape, or topography of the property that necessitates the granting of the variance so as not to cause the undue burden on the property owner? Or is it a piece of property that just won't fit a pool on?
That size pool.
And that's something that you all have to make a determination about, and the BZA grapples with the same thing. But those are the kind of questions you have to ask yourself, because they are, after all, seeking you to waive your own rules. And typically in legislation, you don't see language like extraordinary and exceptional used lightly. That is very, from a legislative drafting perspective, that's powerful terminology. It means, well, and somebody, in fact, when I came and spoke to the BZA a few weeks ago, someone asked me what I have against cabanas. The answer is nothing. I have nothing against cabanas. Cabanas are wonderful things, but you do have to ask yourself in the context of variances, is that the appropriate or requisite use? Having said that, certainly these are to be driven on a fact-by-fact basis. Again, as I started this presentation out, you have an expectation of the applicant coming to you and making the presentation to you of evidence as to why I need this. Another example might be a variance to allow, how about this? I've seen this one. A trailer to be moved on my property so my aged and infirm parents can live on the property when in fact that is not allowed because of some requirement in our code, but they're elderly, they're infirm, they have these medical conditions, and I need to be able to be a caretaker to them, and that's the way we think it's best to try and do that. Now, is that an extraordinary and exceptional situation that may necessitate a variance from your code? I'm not going to forecast it or judge it for you. It could be, and you could be impressed with their presentation that is an extraordinary and exceptional situation. But I'm just suggesting to you, though, that in the rubric of zoning's variances, I have seen a lot of situations where variances were granted where I personally and, quite frankly, quietly didn't believe that they met the conditions of the code.
So
Right.
we're left to be a quasi-judicial body that makes those judgments. What happens if we make the judgment in one case and not in another, and they're proven to be similar?
It's a great question, and here's my rote answer, and I'm not saying rote because I don't think about it. It's because I've been asked it so many times. I think it is very difficult to have a common fact pattern in variances, and I think it's very difficult because the whole nature of a variance is it's supposed to be unusual. And if you begin hearing common fact pattern variance requests, something's wrong. And we had this same discussion. Sometimes people will come to you and ask for variances of multiple lots in the same subdivision. That in of itself is a little bit problematic because really it's supposed to be a case-by-case examination of a particular piece of property. And whenever in any jurisdiction I have someone say, well, I need 30 lots. I need the front yard setback knocked off by 10 feet on every lot. Is that a variance, or do we need to change our zoning code? Because, again, a variance is supposed to be particularized to a piece of property. Let me keep going. I want to get back to all this, but let me keep going through the criteria. Relief, number C, if granted, would not cause a substantial detriment to the public good and surrounding properties. I'm sure you know what that means. You deal with that all the time when you're zoning. So you all have plenty of experience with that. And then D, that the public safety, health, and welfare are secured and that substantial justice is done. And again, anything where you act as a corporate body in the government, the underlying basis upon which you act is to preserve the public health, safety, and welfare. That's standard Georgia law about how local governments act. So that's not anything too terribly challenging. Let's talk about, now let's go back and add a little more meat on the bones. 22.3.1a. Spirit or intent of your code. The very reason that you have a variance mechanism in your code anticipates that you understand there are going to be situations where the literal interpretation of the code may need to be waived or modified. You understand that. That's why you have it in there. If you didn't believe that, you wouldn't have it in there. You'd have no variances. So you believe that. But even within that thought process, you have also concluded We don't want to modify our code in such a way that the spirit and intent of the ordinance is damaged. And again, that's where you get into some of the case law that says you do not approve a variance where it manifests an objectionable product as to how your vision is for the community. You don't do that. You don't grant a variance in that situation. And that's really important because a lot of times people may come to you with variance requests that do in fact offend the spirit of the code. A lot of times they may come to you, for instance, with almost a zero lot line. And within that subdivision, that makes 0 sense to you, and that would totally frustrate your vision for how that community or how that area is supposed to look. You want to make sure that the overriding themes, the big picture, is not damaged. Okay, and that's why that first language is in there. There have been cases before going down to the second criteria with respect to size, shape, and topography. There have been situations where, because of the regulatory overlays on top of the property, riparian buffers, setbacks, things of that nature, that the lot is rendered unbuildable. Okay, you can't do anything with it. Now, if that's the situation, do you think that would be an appropriate place for a variance if the lot is considered unbuildable? And I do. I think that is, if it is a lot that is, for instance, designed to be buildable, it's designed to have a residential structure or a commercial structure, but because of whatever other regulatory principles apply to the land, particularly ones that are under your control and you have the power to vary them, and but for your willingness to vary them, that property cannot sustain any development at all and therefore lead to no economically viable yield on the property, that's a good place for a variance. Because what you don't want to have, and what you don't want to, and you want to make sure you use the variance, is you don't want to have an administrative taking. You don't want to basically have someone come up to a court and say, because of the regulations imposed by the city of Milton, my land is worth 0. I can't do anything with it. Because the court's not going to have to think very long before the court decides, you know what, Milton, you like that property so much, you like keeping it all knotted up in buffers and this and that, you own it. Now we just got to figure out the price for it. So, and again, that's very unusual. Not many pieces of property come in and can make that claim, but if they do, that's a good reason for it.
But Ken, isn't there a difference, at least I've always felt when I was on the BZA that there was, whether or not it was a lot that the developer should have known was unbuildable at the time they platted it, and one that became unbuildable later on because of a change in zoning laws or a change in some kind of setbacks or easements or something like that? Because, I mean, we had cases where a developer they were building the whole subdivision out, and they should have known that one of the lots was completely unbuildable.
It's a good point, and it's a point that could be argued very aggressively by the local government, that the builder was on notice that this lot was not going to be viable, and in the pursuit of due diligence, they should have made themselves aware. That is going to be fact-driven, quite frankly, and a fact-driven determination as to whether that is the case. I have certainly seen that situation before. My only concern, Councilmember Thurman, is that if the local government accepts a plat and records the plat, and somebody stamps off on the plat, at least from the landowner's perspective, they could argue, you stamp my plat, you record it. I'm not suggesting to you that is therefore a guarantee of buildability. I'm not suggesting that to you. I'm suggesting that if I'm that owner, I'm going to make that argument. If I'm the local government attorney, which I am, I'm going to make your argument that, and not every lot is buildable. There's going to be some situations where that is true. For instance, are they paying taxes? Have they been assessed by the local government at a rate that would be considered a fair market value of a buildable lot? That's important. It's going to be fact-driven in some situations.
Ken,
Yes, ma'am.
along those same lines, that whole premise of buildable lots, oftentimes we'll hear from an applicant, whether it be as a city or even back when we were over unincorporated Fulton County, where somebody wants to claim that they want to have a particular level of intensity of use. And of course, the argument would be, well, but I purchased this land with the intent of having a more dense use on this property. Can we talk a little bit about the distinction between some buildability, to make up a word perhaps, and what is a maximum that's allowable? Is that not every property, not every lot is necessarily allowable for all levels of density, and that oftentimes that becomes the issue?
Well, and that's important because, again, when I say the example I was using was a lot or a development that has zero economic viability. The court, though, does not believe the local government has the requirement or obligation to maximize profits for these individuals. That's not your job either. It's one thing to say, I can't do anything with my land. I can't build a residential structure on it. I can't build a commercial structure. I can drive no economic use of the property. It's another thing to say, I can't pay back my lender because I really bought the property for a lot of money, probably more than I should have, and now my development's upside down. That's not your concern, and it shouldn't be. Your interests are not necessarily economic interests. Your interests are planning, community development, and the intent of the law that you all have adopted, and ensuring that law, the intent and the spirit of the law is preserved.
Can I have a question? To Karen's point about the piece of land that a developer might have, when he platted the land, might have had that as like a end unit, and that was not going to have any building on it whatsoever. And then he comes later and he says, well, I want to now put a townhome there. And the land, because of whatever reason, the buffers or whatever, it's unbuildable. I would take that as being, you knew what you were getting into before you knew what you were getting into, basically. Now you want to build on it. In order to prevent that from happening, I would think that we would need to insert after size, shape, and topography, not caused by the variance applicant or something like that, because the way this is written, that in and of itself, they could buy a piece of land that they know was not buildable and qualify for the variance provision.
Well, and to add to your point, Councilmember Tart, a lot of times it's the case as well where they will buy the property and then they will have their engineers come and lay out the property pursuant to a site plan that they like. And inevitably, there may be on the margins a lot or two that are throwaway lots, and they simply can't put anything on there. But that's how they had to work all the lots in to maximize their yield. And you may say, how is this my fault? You laid this out. You engineered it. You knew the topo on the ground. You knew all the things that you know. And that may be where you rely, even without getting to the new language you're talking about, council member, you may say, I don't find that represents an extraordinary and exceptional situation. I conclude that is simply a situation that arises within the context of what you do. You know it. I know it. It's just the way it works. But I understand your point, and that's something we can look at.
I think where we saw it most often was where they had platted a subdivision, and then once the engineering was finalized, realized that the detention pond needed to be about twice the size of what they had showed it, so the detention pond took up most of a lot,
Right.
and it made a lot basically unbuildable.
That's right. And and again, we see, I have seen that plenty of times where the developer will come back in, and how many times have I heard this? We have now, based upon demographic studies, believe the price point in this neighborhood will support a bigger home, and that's a nicer product, that's a prettier product, that's a more attractive product, that increases your tax values. But to bring in that nicer product, the 3-car garage, the 6 bedrooms, 4.5 baths, I need variances for the entirety of the subdivision for my front and side yard setbacks. And let me tell you, a lot of jurisdictions like that argument. Okay, more taxes, a prettier product, a nicer home, a higher demographic of individual moving in that subdivision, sold, variance granted. I'm just suggesting to you, though, I'm not sure that's so much as a variance as that is a code modification by another name. That's what that is.
Ken, can I also ask this question is, as we talk about different land lots and arguments that may be presented to us, obviously where we are in Milton, we've got a lot of steep slopes, we have topographical issues, we have a lot of streams, a lot of waterways, and by the very nature of where we are as a community, a lot of times land is not going to yield the same density that it might in an area that either has sewer or it has less waterways or it doesn't have as many steep slopes. It's always been my belief that the lay of the land is not necessarily a reason for variance, is that sometimes certain land is not meant for certain types of density or certain configurations. Can you just speak to that a little bit?
I
think we
can.
do have a unique situation in Milton.
I can, and I think that goes back to a couple things. First of all, the Milton Code was written with an eye toward the community that it was being designed for. So therefore, you have to ask yourself, does the Milton Council that adopted the code understand the topography of the jurisdiction that you're in? Well, you probably did, and you probably do, and you've got expert planners that tell you these things and will help you lay out, for instance, minimum lot sizes and densities in certain areas. So you have to go back and think, is the fact that you're in a steep slope an exceptional, extraordinary circumstance when that is in fact the basis upon which we drafted the code in the first place? And certainly we're aware of those conditions when we drafted the code. And the answer is yes. Now, I'm not suggesting to you that even though that's true, an applicant still couldn't come to you and present, as it says, credible evidence that the topography of my particular piece of property is such that I need to be given special consideration from the literal language of the code. But I hear you loud and clear, and I want to also emphasize, because I'm going to keep coming back to this theme, that the variance is not a mechanism for maximizing yield. That's not what that's about. And again, you may say, well, then what is it about? It's about exactly how it's drafted in the code. Courts are going to give you wide and broad deference in how you interpret this code, and in fact, even how you wrote it. This was a lot of effort went into this to get these exact words just right, and a court is going to be very deferential to you. You drafted your zoning code. You have now drafted the mechanism by which you can vary that code. Short of a patent abuse of discretion by you, they're going to support your efforts on that. Let me, got about 25 minutes. Let me talk, if you have the items for consideration regarding variances, let's go through those. Those are a very fertile source of discussion. 13 minutes?
Talk to us a little bit about the idea that we might abuse our discretion with variances. In other words, there's a statement that I've used in the past and have been part of in past jurisdictions, that variances are not typical. They're not the norm. We're not here to grant variances.
Right.
So talk to me a little bit about that, how the court perceives, and when that may, if you've got any examples of where that may have been the case, where there's been abuse of variances.
And again, Councilmember Diverse's point is a good one. And that's my number one bullet, and then I'll talk about the abuse of discretion standard. But the number one bullet is, and the reason I put that as number one is it's kind of self-evident. The whole definition of variance is supposed to mean that. But I have seen boards of variance appeals, and not Milton, I've certainly worked with others, that you give somebody a hammer and every problem's a nail, right? You've seen this. If anything comes before them, because they're in the variance granting business, well, then every case tends to lend itself to a variance, and you almost begin to see a mindset of, I'm going to grant you a variance unless you talk me out of it, almost. And that's kind of curious because that's exactly back to front. Variances are supposed to be the exception, not the rule. That's as clear and as succinct as I can say it. Your discretion with respect to those variances will be upheld short of an abuse of your discretion. And the court is going to look at you and say, look, I'm going to give you a very wide berth in making the decisions that you make unless the decision that you made so departed from what would be a reasonable exercise of your discretion that the court simply cannot tolerate, simply cannot sanction what you have done. A perfect example to me would be a case, and let's to address Councilmember Thurman's a concern, let me at least paint my scenario such that it was a lot of record, platted, the individual had been paying taxes that clearly suggested that it was being appraised by the local appraisers as a buildable lot. They had been paying those values for years. The jurisdiction then imposes new buffers that now swallow the entirety of the property in buffer. They come into the office to pull a permit, and the folks in the permitting office say, you can't build on it at all, not one thing. It's totally subsumed by a buffer. They come to you, they make a very effective argument with credible evidence that a variance should be granted, and because of, for no reason, let's say political pressure, red shirts and torches in the gallery, and no, not in my backyard, and you all say, without any really compelling rationale, say no. That's the situation, Councilmember DeVersa, where I think a court, upon reviewing that, would find that the council had abused its discretion. You have discretion, but you did not, in good faith, exercise it. And there was, I hate to say, in that situation, there would be only one answer, but that's one of those cases which tends to lend itself to having only one answer.
And to make sure I'm clear, in that situation, you were indicating that we would have gone in, we being a jurisdiction, would have gone in and changed the buffer. It's not to imply that a parcel shouldn't have to meet the standard. It's that if somebody owned a parcel under the preponderance of belief that they could develop it, and then there was a change that precluded any development, not necessarily that a rezoning would therefore allow a more intense use, but if it had been zoned AG1 or residential, that doesn't mean that any use is then possible, just that if a jurisdiction had gone in and replaced those with more stringent buffers.
Right.
Okay.
That's correct.
Ken, in that same example, would that constitute a taking?
If you don't grant the variance, it might. And again, that's where the applicant, and I've seen this happen, the applicant comes to the jurisdiction and says, look, give me a variance. I don't want you to buy my land. Give me a variance, and then I'll build on it. And that's when hopefully you come see me and I say, that makes good sense. Let's go.
How many parcels do you feel have to be included before it's really a rezoning in a subdivision scenario? 2?
That's a great question. No, I mean, I'm not, I don't know. No, it's probably more than 2. And it's one of those things where I can't hardly define it, but I know it when I see it. And it's just something I would have to work with you all on. But you just have to be careful about that.
Careful.
As far as how many variances you want to give in a subdivision before you have really violated the spirit and intent of the zoning code. Because if you start giving what I call mass variances, then for that subdivision, you all have basically changed the code with respect to setbacks and buffers, et cetera. I'm not suggesting that a case couldn't be made where that was appropriate. I'm simply saying that I've seen that way too many times. And typically the arguments that are made in support of that are great arguments, like I talked about, better price point, better, bigger house, all those things.
That boils down to density as well, with
That's right.
regard to increasing.
That's
We
right.
have those cases before us now, that we have to grapple with, so you might be educating us sooner than later.
Let me,
I think, if I'm not mistaken, that we addressed that in the latest revision.
I think we did.
Because we had an issue.
There's a percentage, a number, and a percentage.
Like
Yeah.
number 5.
5 and then like 10%,
10%.
whichever's lower or whatever.
And that's, of course, I think when it comes to the BZA, but it still leaves us, when something's before us and not in front of the Board of Zoning Appeals, it would seem that same mindset applies, is that if, based on what I'm hearing you say, is that if we suddenly look at the entirety of something, and if the variances are going to become then the rule as opposed to the exception, it's not a one-off, it's really effectively a rezoning. It's not a variance because you had a one-lot situation.
Right. And we did discuss this within the context of changing the code, because Councilmember Tartt's right. We tried to cross this line as carefully as we could, but I'm only suggesting that I've seen more than one occasion where it's been subdivision-wide, or at least a significant portion of subdivision, and you all just need to be very wary of that if you saw it. If we could, just so I can get to it, could we go on the items for consideration regarding variances? Could we talk about 6, 7, and 8? those are things that I see routinely when people are requesting variances, and I just want to mention them to you. I can't tell you how many variance application hearings I've been in front of when I have seen a variance applicant come forward with letters from their adjoining property owners, and they say, my adjoining property owner doesn't have any objection to granting these variances. And that's certainly great. And certainly that's something you all can take into consideration from the standpoint of their neighbor doesn't mind. But just be mindful that that should neither work to grant a variance or deny a variance. Because you don't want to be in a situation where simply because someone is fine with their next door neighbor doing that, that is therefore meets the variance criteria. I think you have a lawful duty to go through those criteria and make determinations for your own whether they have been satisfied. If there is something that presents no hardship, is not an exceptional or extraordinary condition on the property, but the neighbor doesn't mind next door, that doesn't necessarily mean a variance should be granted. Conversely, if the neighbor next door doesn't want it and comes and vociferously protests and says, don't grant the variance, but you find that there is an extraordinary and exceptional circumstance on the property, I don't think it is lawful to give a neighbor, an adjoining property owner, a pocket veto over a procedure that you've put in place. If the neighbor is upset, and I have seen local boards do that and say, listen, if there's objection to it, we're not going to grant it. That's not the criteria. That shouldn't be dispositive. Secondly, number 8, I have seen jurisdictions where they'll have the public hearing and no one will come and speak in opposition to the variance, and the local board now sits back and says, great, we'll grant the variance then. There's no opposition. All I would suggest to you there is just because the local community isn't in an uproar or doesn't take the time to come down and speak doesn't mean that should be an automatic grant of variance. I mean, you could make just as compelling an argument as the citizens may think that you will correctly apply the variance criteria, and if they don't meet it, they won't get it. And there was no need for me to come down and speak. So again, those are just some things. Yes, sir.
A couple of scenario questions for you. One, let's say that we've been asked to award a variance. We don't find a hardship. There's no hardship that's really demonstrated in the evidence, but this body grants the variance anyway.
Yes.
Would that be grounds for an adjacent landowner to take action against the city?
Could they challenge?
Has there been case law about that happening?
Certainly there would be a mechanism for someone that has standing to pursue a challenge to the variance. I mean, for instance, if you grant a setback variance that allows the property owner to build a building 2 feet away from his neighbor's property, certainly he would have the right to come and challenge that and make the case that you had abused your discretion. You had not acted within the 4 corners of your variance criteria. And Councilmember Tart, that's where when you make your decision on the variance, particularly with an approval, it would be helpful to have some findings. For instance, I make a motion to grant the variance in case number X because I find that the topography of the property presents an exceptional, unusual situation due to the fact that they have no economically viable use in the property, or they can't put this desired addition, which we find is needed, and provide that in your motion such that if there's a challenge and the court scratches its head saying, why did you take this action, it's right there, and you can show why we took the action we did, and I think that's important. But yeah, if there's no finding of a variance or of the criteria have been satisfied, yeah, that's a great reason to have it over time.
And then my second question has to do with prior use. Let's say there's a company or business that's been operating on a piece of land for 15 years, and they are cited for operating illegally, and they come before us to apply for a special use permit. And in order to keep doing exactly what they've been doing for the past 15 years and operate to that level of intensity, they need buffers for, they need variances for buffers and setbacks and all kind of things. Is that a hardship?
I'm sorry.
Is that a hardship?
The question is, is that a hardship because they can? Let me think just a second. Let me collect my thoughts on that one. Here's the deal. Here's what I think about that. And let me ask, maybe I can ask a question for clarity on the fact pattern. If they require or now have to get a special use permit and all these variances, can I assume that before they did that, they were operating illegally?
Yes.
Then I am not going to conclude that there is necessarily a hardship, and I'm going to apply what I would consider some traditional vesting analysis. And what you look at with vesting is in other words, I get to do something that's non-conforming because I've been doing it for years previously, and I want to keep doing it in the future irrespective of the rules that have changed. And what the court says is, but to vest, what you were doing previously has to have been done in all respects lawfully for you to enjoy the benefits of vesting. Well, that situation strikes remarkably close to that. Before I'm going to be able to come up here in front of the council and make an argument for hardship based upon a prior use, my position to the council from a lawful standpoint would be, at a minimum, that lawful use that they had previously or historically been doing would needed to have been lawful in the first place. And if it wasn't, I think that significantly diminishes their argument. Does that answer your?
It does. Thank you.
Chris, are we done, or do we?
Well, we got, is there
Any more questions?
anything else you want to add?
No, I think that's it. I will try and email out the Georgia case law that I had provided to you. You've got the items for consideration. We could talk about sign buffers or sign variances and riparian buffer variances. They are controlled by a little bit of different criteria. Sign variances have their own specific criteria. They are, because they involve First Amendment concerns, they are a whole animal of a different color. We need to be very careful on sign variances. And then riparian buffers in Chapter 14 are also their own animal. But for purposes of this evening, I hope that was at least a little bit of a primer, answered some of the typical questions. And if you have any questions, you know how to find me.
Okay.
Can I ask just one more?
One more.
Just when you were talking, Ken, about under 22.3.1, both C and D, where it talked about that the relief would not cause substantial detriment to the public good and surrounding properties. And I know you said that we'll talk about riparian buffers later. I've always been of the belief that substantial detriment also applies to things like water quality, that stormwater runoff and things of that nature, that has a public impact. Is that fair to say that when something that would be of negative impact to a waterway that obviously impacts other folks that are downstream?
It absolutely does. And in fact, what causes a substantial detriment to the public good could be things like water quality, could be aesthetics. How does it look? How does it appear? Obviously, the manipulation of soils in the buffer. I mean, you get into soil and sedimentation issues. I wish I could tell you that I had a quick and easy definition of those sorts of elements that can contribute to cause a substantial detriment. But the reality is you as the elected officials of the city know those things that cause the detriment to the public even better than I do, and those are the principles you have to apply.
And the second part of that is just that when we talk about detriment, I would also perceive this, and I'd like your input, is that if we start to approve variances where that becomes the norm, it no longer is the exception, it would seem that the detrimental impact to the public is that we're undermining the very zoning laws that we're supposed to be upholding.
Yeah, that's certainly out there. That's kind of the big elephant in the room with this awesome power that you control, is to certainly use it sparingly, because if you use it too often, and again, to be fair, I have seen jurisdictions where a particular, and I'll just use an example, a particular landscape strip requirement in one of our overlays continually came up as a request for variance, and eventually we just said, look, time out, board. It was a board, not a council. This is you all have granted these every time they're asked for it. Here's what I recommend you do. I would recommend you modify the code and take that out, because clearly you have no interest in enforcing it. Now, I said it a lot nicer than that, but the point was the same, and so it goes to your point.
Thank you very much.
Wouldn't you agree, though, getting into the aesthetic evaluation, they're getting into more of the subjective area,
I couldn't agree more.
which is a lot more difficult to deal with.
It is. Councilmember Love's point is a good one. When you start talking about aesthetics and the public good within the realm of aesthetics, you're talking about the eye of the beholder in a fairly meaningful way. But I will say this. I mean, the courts have routinely held that aesthetics, how a community looks, is part of your public safety and welfare criteria that you look at. That's the whole basis upon which most sign codes are adopted, is aesthetics. Certainly traffic safety is part of that, but aesthetics, the court has said, that's a legitimate thing for a board or a council to look at.
And isn't that further emphasized by the fact that we've got overlays? I mean, it would seem to me that it provides us as a jurisdiction with even additional emphasis that the intent and spirit is that we are upholding those aesthetics as reinforced by overlays that were adopted by law.
Well, Butt in, we've got 2 other meetings scheduled, so as Ken said, any other questions, you're welcome to contact him on that. Thank you. At this point, I'm going to adjourn